I want you to imagine something. You're a small business owner in upstate New York. You work 6 days a week. You have 8 employees. You run a tight operation. And over the last several years, the state government in Albany has made it a personal mission to make your life harder in ways that are almost impossible to believe if you haven't lived them. They passed a law that lets anyone with a felony conviction, assault, robbery, drug trafficking, get that conviction sealed from their background check after 8 years. You hire that person, not knowing what they did, and something goes wrong on your premises. You are liable. They are protected. You took all the required steps, and you're still the one holding the bag. Then they passed a law requiring you to give every pregnant employee 20 hours of paid prenatal leave on top of every other mandate already stacked on your shoulders. Then they put a $9 plus congestion fee on your delivery drivers every time they drive into Lower Manhattan. Then they passed a constitutional amendment that critics say opens the door to stripping your parental rights over your own children's medical decisions. And through all of it, Albany told you that if you object, you are a bigot. You are a threat to progress. You are on the wrong side of history. This isn't a hypothetical. This is New York State in 2026, and the architect of all of it is Governor Kathy Hochul and the Democrat supermajority that has turned the Albany legislature into a rubber stamp for the most aggressive progressive policy agenda in the country. Today, I'm gonna go through it all, law by law. I'm gonna show you exactly what they've done, what it actually means in practical terms, and what the pattern tells you about what they're trying to build.
The independent media company The Truth in the Darkness Network presents the Courage in the Darkness show with your host, Philip Roberts, shutting down the narrative and bringing you the truth that the indoctrinated leftist sheep can't handle.
I'm going to start with the 2 laws that tell you the most about how Albany thinks about the relationship between law-abiding citizens and the people who prey on them. The Clean Slate Act went into effect on November 16th, 2024, signed by Governor Hochul. Here's what it does. After a person is convicted of a felony in New York State and completes their sentence, including all parole and probation, their conviction is automatically sealed from most background checks after 8 years. For misdemeanors, the waiting period is 3 years. The sealing is automatic, no petition required, no judge reviewing the individual case. The state just does it. The records still exist. This is not an expungement where the record is destroyed, but they are hiding all of this information from employers, landlords, and licensing bodies that ordinary people rely on to make informed decisions about who they're dealing with. Now, the left will give you a list of exemptions and tell you not to worry. They'll tell you that murderers and sex offenders are excluded. That's true. Class A felonies like murder and terrorism are not eligible for sealing under this law. Sex offenses are not eligible. Law enforcement will still have access. Employers who are legally required to do fingerprint-based background checks, like schools and child care providers, will still have access. And they will use all of that to tell you this law is reasonable and its critics are fear-mongering. Here's what they won't tell you. The list of felonies that are eligible for sealing under this law is long. Robbery, assault, drug trafficking, weapon offenses, burglary, grand larceny. A person who held up a convenience store at gunpoint, served their time, and stayed out of trouble for 8 years will have that conviction sealed from the background check you run when you hire them. You won't know. The law literally makes it unlawful discriminatory practice for you to inquire. And here is the part that should make your blood run cold. If you hire that person without knowing their record and something happens, you can't even use the sealed conviction as evidence in a negligence lawsuit against you because you had no knowledge of it. The law actively removes your ability to exercise due diligence and then removes your legal protection for the consequences. The state legislature and the governor looked at that situation and decided the felon's privacy interest outweighs your right to know who you are letting into your business, your home, your life. That is the ideological worldview this law expresses. And it is now the law of New York State. Then there's the companion piece, which went even further. A 2025 New York State law restricts employers, schools, and government agencies from requiring people to show their own criminal history records as a condition of anything. Think about what that means in practice. You cannot require a job applicant to provide their own criminal history documentation. The employer is not just prevented from accessing it, the applicant is protected from even having to acknowledge it. The legal fiction that Albany is constructing piece by piece is one in which a person's criminal past simply does not exist for most practical purposes, and any employer or institution that tries to pierce that fiction is the one who gets punished. That's not compassion. This is a deliberate deconstruction of the information system that allows a functioning civil society to make rational decisions about risk. And ordinary New Yorkers, small business owners, landlords, parents, neighbors, are the ones who pay the price when those decisions go wrong. Now let's talk about the green light law, because this one has a history that tells you everything you need to know about how Albany thinks about the federal government, national security, and the people in this state. In 2019, Governor Andrew Cuomo signed the Driver's License Access and Privacy Act, known as the Green Light Law. It did two things. First, it allowed undocumented immigrants, people who are in this country illegally, to obtain standard New York State driver's licenses. Second, and this is the part that created a national security crisis, it prohibited the New York DMV from sharing its records with federal immigration authorities. Not just restricted sharing, prohibited it, unless a court order or judicial warrant compelled disclosure. The New York DMV would actively withhold its data from ICE, from Customs and Border Protection, from the Department of Homeland Security. Let's be precise about why that second provision is so dangerous. State DMV databases are not just records of who's licensed to drive. They contain photographs, addresses, date of birth information, vehicle registrations, and links to other identifying data. ICE has used that data to build cases against narcotic smugglers, human traffickers, gang members, and child predators. DHS acting secretary there, Chad Wolf, told the public exactly how, in the year before the green light law took effect, ICE used New York DMV records to arrest 149 child predators, identify or rescue 105 human trafficking victims, arrest 230 gang members, and seize more than 6,400 pounds of illegal narcotics. Those aren't abstract statistics. Those are real victims protected and real criminals taken off the streets. And Albany looked at that record and decided the privacy of undocumented immigrants was more important. The consequences were immediate and direct. In February of 2020, the Department of Homeland Security announced that New York residents would no longer be eligible to enroll in or renew their access to trusted traveler programs, Global Entry, Nexus, Sentry, and FAST. About 175,000 New Yorkers lost their trusted traveler access or had their applications frozen. Law-abiding New York citizens who had nothing to do with the green light law paid the price for Albany's decision to shield illegal immigrants from federal law enforcement. And it didn't stop there. In 2025, under the current Trump administration, Attorney General Pam Bondi filed a federal lawsuit against New York over the green light law. The DOJ's position is straightforward. The law is unconstitutional because it interferes with federal immigration enforcement. Governor Hochul's response was to dig in. She called the federal access request an attempt by DOJ and the Trump administration to get unfettered access to New Yorkers' data, which is a deliberate misrepresentation of what ICE was asking for, which was access for legitimate law enforcement purposes, not surveillance of law-abiding citizens. Here's the bottom line. New York State, under both Cuomo and Hochul, made a deliberate policy decision to make it harder for federal law enforcement to catch criminals who are in this country illegally. They didn't just decline to assist, they actively structured the law to obstruct. And they did it in a state that lost nearly 3,000 people on September 11th. A fact that the DHS noted explicitly in its response to the green light law. The state of New York, more than any other state in America, knows what happens when you treat immigration enforcement as a political inconvenience rather than a national security necessity. And they built a law to obstruct it anyway. Now let me walk you through the rest of the agenda, because the Clean Slate Act and the Green Light Law are the most dangerous pieces, but they're not the only ones. Albany has been busy. In November of 2024, New York voters approved Proposition 1, a constitutional amendment to the state's Equal Rights Amendment. The amendment adds gender identity, gender expression, and sexual orientation to the list of protected characteristics in the state constitution. Supporters presented it primarily as a protection for abortion rights. Critics argued, and continue to argue, that the gender identity provisions go much further than the campaign advertising suggests, and that those provisions could be used in litigation to challenge parental rights over gender-affirming medical decisions for minors. The legal implications are still being worked out in the courts, but the concern is specific and legitimate. By constitutionalizing gender identity as a protected characteristic at the same level as race and sex, New York has created a legal framework that could be used to argue that parents who object to certain medical interventions for their children are engaging in unconstitutional discrimination. Whether that argument succeeds is a legal question. That the argument is now available in New York's constitutional structure is not a question at all. It is the text of law. Then there's the congestion pricing. Starting in 2025, anyone who drives a personal vehicle into Lower Manhattan below 60th Street pays a toll of $9 minimum, going higher for larger vehicles in certain times of day. The stated purpose is to fund the Metropolitan Transportation Authority. The practical reality is that the people who get the hardest are not Manhattan executives who can expense the toll or take a taxi. The people who get hit the hardest are commuters from the outer boroughs, from New Jersey, from Westchester, working class people who drive because their jobs require it, or because they live in neighborhoods without convenient transit options, or because they're picking up children or caring for elderly parents and cannot redesign their lives around a subway schedule. Albany took a financial burden that should be spread across the entire state budget and dropped it specifically on the people who drive into the city, which is disproportionately not the wealthy progressive residents of Manhattan who championed the policy. In January 2025, a new law took effect requiring private employers to provide 20 hours of paid sick leave specifically for prenatal medical appointments, on top of the paid leave mandates that already existed in New York law. This is in addition to the state's existing paid family leave program and existing paid sick leave requirements. For a large corporation with a human resources department and a legal team, this is a compliance item. For a small business owner with 8 employees running on thin margins, this is one more mandate in a long list of mandates that makes every hiring decision more expensive and more legally risky. And then there are the laws that fall into the category of legislative priorities that most Americans outside of Albany would find hard to believe are actually receiving legislative time. In 2024, New York banned the sale of dog and cat fur. In 2020, the state banned direct contact between members of the public and big cats like tigers and lions, the so-called tiger selfie law, because people were taking photos with exotic animals for dating app profiles. These are not the most consequential laws on the list, but they're indicators of where the attention and energy of the Albany legislature is being directed while small businesses close, crime goes unsealed, and illegal immigrants are shielded from federal law enforcement. These are the priorities of a political class that has so completely insulated itself from the consequences of its own governance that it can afford to spend floor time on tiger selfies. The social media warning label law passed in 2025 requires social media companies to display warnings about the mental health impact of their platform's features on young users. The stated goal? Protecting children from the documented harms of addictive social media design is one that responsible people across the political spectrum can engage with. The implementation, however, is a government mandate on private companies about what speech and warnings must appear on their platforms. The line between protecting children and government-compelled speech on private platforms is one that Albany crossed without much public debate, and the legal challenges are already forming. What you see when you lay all of this legislation out side by side is not a random collection of progressive ideas. It is a coherent governing philosophy. A philosophy that says the state knows better than you do about what risks you should be allowed to consider in your hiring decisions. The state knows better than the federal government about which law enforcement cooperation is acceptable. The state knows better than parents about the medical decisions their children should be able to make. The state knows better than the market about how transportation in New York City should be funded. And if you disagree with any of those judgments, there is a law telling you that your disagreement is not just wrong, it may be illegal. I want to step back from the legislation for a moment and talk about what is actually underneath all of it. Because I think if you look at the pattern of what Albany has been doing, not just the individual laws, but the governing philosophy they express, you are looking at something that goes deeper than politics. You're looking at a worldview, and that worldview is in direct conflict with the worldview that built this country and that built the Christian civilization that made the kind of ordered liberty we call America possible in the first place. The Clean Slate Act rests on a particular understanding of what a person is. It says that your past does not define you. That after a period of time, it should be as though certain things you did simply did not happen. There's a Christian concept buried somewhere in that impulse. The grace of God is not contingent on a spotless record. All of that is true. But the Clean Slate Act is not offering grace. Grace is freely given by a God who knows everything. The Clean Slate Act is hiding information from people who need it to make rational decisions. It's not saying this person has changed and deserves a chance. It is saying you are not allowed to know this person's history. And if you find out anyway, you can be sued. That's not grace. That is coercion dressed up in the language of compassion. The green light law rests on a different but related idea, that the borders of a nation are morally irrelevant, and that any distinction between people who are here lawfully and people who are here unlawfully is itself a form of injustice. This is a genuinely radical position. Every functioning society in the history of the world has recognized that it has the right and the responsibility to determine who may enter, on what terms, and what obligations those people have to the community they're entering. The Christian tradition does not say that foreigners have no claim on our hospitality. It says quite the opposite. But it also has never said that a nation has no right to govern its own borders. The green light law does not just offer hospitality to immigrants. It actively obstructs the federal government from enforcing the laws that govern who may live here. That's not hospitality. That is institutional defiance of legitimate authority dressed up as compassion. And the constitutional amendment, the one that critics argue could be used to challenge parental rights, strikes at something even more fundamental. The family is the basic unit of human society. It predates the state. It predates the government. God did not invent the Department of Motor Vehicles. He invented the family. The idea that the state can interpose itself between a parent and their child's medical care under the banner of constitutional rights is a direct challenge to the divinely ordered structure of human society. Parents are not just legally designated caretakers. They are the people God has placed in authority over children, accountable to Him for how that authority is exercised. Albany is not just passing laws. It's making a theological claim. It's saying the state's judgment about what a child needs supersedes the family's judgment. And that claim is wrong. Not just politically wrong, fundamentally wrong at the level of how human beings are made and how human society is supposed to be ordered. The Christian response to all of this is not despair. And it's not simply voting, though voting matters and you should do it. It is the patient, persistent building of institutions, communities, and cultures that operate on different principles. Schools that teach the truth. Churches that hold fast to what they believe. Families that make their own decisions. Businesses that build networks of accountability outside the state's regulatory apparatus. That's not rebellion. That is exactly what free people in a free society are supposed to do. And Albany cannot seal that record. Let me tie it all together. New York State, under Governor Kathy Hochul and the Albany Democrat supermajority, has spent the last several years constructing a legal framework that systematically shifts power away from ordinary citizens and toward the state and the groups the state has decided to protect. The Clean Slate Act hides criminal records from their employers, landlords, and institutions that need them to make informed decisions, while making it illegal to even ask. The companion criminal history prohibition goes further, preventing people from being required to disclose their own records. The green light law gives driver's licenses to illegal immigrants, and then actively obstructs federal law enforcement from accessing the data that ICE used to arrest child predators, rescue trafficking victims, and take gang members off New York streets. The constitutional amendment embeds gender identity into the state constitution in ways that critics argue could be weaponized against parental rights. Congestion pricing puts the financial burden of MTA funding on the working class commuters least able to absorb it. And the paid prenatal leave mandate adds one more financial weight to the small business owners who are already carrying the heaviest load in the state. None of this happened by accident. All of it flows from a coherent governing philosophy that believes the state is smarter than you are, that the interests of the groups Albany has decided to protect outweigh your right to make informed decisions, and that anyone who objects is on the wrong side of history. That philosophy has been in Albany long enough to produce exactly the results you would expect. Businesses are leaving New York. Residents are leaving New York. The tax base is shrinking. And the people left holding the bill are the working and middle class New Yorkers who cannot afford to move. This is not sustainable. And the good news, the reason I keep doing this show, is that it is not invisible anymore. People see what's happening. They're naming it. They're pushing back. In school board meetings and city council chambers and primary races and state legislative districts, ordinary New Yorkers are starting to fight back against a political class that has treated their state as a laboratory for ideological experiments at their expense. That fight is worth having. Albany is not invincible. No political machine ever is. And the truth, told clearly, consistently, without apology, is the most effective weapon in the arsenal of anyone who wants to see New York governed by people who actually respect the citizens who live there. I'll keep telling it every week. That is the mission. And before I go, I need to ask for your support because this show runs on you. Not on advertisers, not corporate money, not political consultants who want to manage what I say and which laws I cover and which politicians I name. Just you, the listener who knows that independent media telling the truth is worth fighting for. What you heard today, the Clean Slate Act, the Green Light Law, the Constitutional Amendment, all of it laid out in plain language without the spin Albany puts on it. You are not going to get it assembled this way anywhere else. The mainstream press in New York, they sure ain't going to do it. The national media is not paying attention. I am. And I can only keep doing it because of listeners like you. Check out the website at titdusa.com and check out the Stand Against the Silence campaign. Look at some t-shirts, coffee mugs. I don't have a lot of coffee mugs on there, but I do have a couple of them. If you're already a subscriber, thank you from the bottom of my heart. Share this episode. Send it to someone in New York who needs to hear it. I'm going to send it to all of my people that don't listen to me regularly. That's how this grows. You could find Courage in the Darkness on YouTube. I'm on Spotify, Apple Podcasts, Patreon. Now I'm on Rumble. Subscribe wherever you listen. Leave a review. It matters more than you know. The silence they want from us, we refuse it every single week. Stand with us, support the mission, refuse the silence. God bless you. I'll see you next time.